Good evening, everyone. I, Saquib Rahman, Senior Lecturer at the Department of Law at North University, would like to welcome you all to our webinar today. It would be a pleasure on our part to be able to listen to Professor Anna van Aaken, who has very kindly made the time to talk on a very interesting issue, rewarding in international law. Before we request Professor Aaken to start, I would like to bring to the notice of the listeners that the chat box is open and that they may address any questions there in the box. The audience is requested to please keep their microphones off at all times. And lastly, I would extend my thanks on behalf of the Department of Law to all of you present here today. And regarding our guest speaker, Professor Anna van Aaken is Alexander von Humboldt Professor, Chair for Law and Economics, Legal Theory, Public International Law, and European Law within the Faculty of Law at the University of Hamburg, and is currently the Director of the Institute of Law and Economics. As a lawyer and an economist, Professor Aaken's research areas are in public international law, focusing on international economic law, theories of international law, regime interactions, and shared responsibilities in international law. She also takes interest in behavioral economics and law, legal theory, and deliberative theory. Professor Aaken is the co-editor of the Journal of International Dispute Settlement and is in the editorial board of many acclaimed international law journals at present. She's also the chair of the Research Council at the European University Institute and has formerly served as the vice president of the European Society of International Law. Professor Aaken was also a visiting professor at many law schools of high repute, including Columbia and NYU. Then before we ask Professor Aaken to start, I would like to request Professor Rizwanul Islam, Chair of the Department of Law, for his introductory remarks.
Thank you, Saquib. Good morning, good evening, or good afternoon, respected colleagues, and of course, our esteemed speaker, Professor Aaken. Now, as a teacher of public international law, often I would encounter a question from my students in the early part of my course that there is no police, there is no sheriff. Why on earth states comply with international law? Now, this is a question which is not asked by undergraduate law students. This is a question that over decades have been asked by international legal scholars, by international relations scholars, by political scientists, and many others. Some have sought to answer this question by saying that maybe international law is not really like other laws, or it's just morality than law. Some have tried to argue that no, the coercive force that may not be easily visible in international law, it still exists. Some others have sought to give different other explanations. Now, Professor Aaken's groundbreaking recent article published in the American Journal of International Law has tried to answer this question, but in my understanding, in a very innovative and in a new, rigorous way. She has sought to address the question from the point of view of rewarding, that how can various forms of reward or incentives ensure more compliance with international law. Her analysis is theoretically rich. The examples that she cites and the various sub-areas of international law that it covers is really, I would say, comprehensive, and it has generated a lot of interest among many scholars within a very short span of time. So much so that there has been an ASIL unbound issue which has addressed the same question from many different vantage points with many different perspectives. And dare I say that this is not a question that is going to go away anytime soon. I'm quite sure that Professor Aaken's work would be cited, would be read, and read it with interest in years to come. I look forward to Professor Aaken's talk. I thank her on behalf of my colleagues at the law department, and I also look forward to the questions from the audience and how Professor Aaken addresses them. I'm sure it's going to be an interesting session. Thank you all.
Thank you very much. Professor Aaken, whenever you're comfortable.
Thanks so much, and thanks so much for the invitation, Professor Rizwanul. I really appreciate being able to talk to you, and I very much look forward to your questions and the discussion, which it hopefully generates. So I start sharing my screen immediately, and you are free to interrupt me whenever you like to do so. I think Saquib would alert me if there is a question, because now I see my screen and I don't necessarily. Okay, perfect. This is joint work with a research assistant at my chair, Betul Simsek, who is actually an economist, but working in law and economics. So we wrote this paper together. And what was the motivation? The compliance discussion in international law. And just usually people think about, when you want to enforce something, you always think about a no, a sanction that starts with, how you educate your children. Is it better to always say no? Does that reach your goals or does it not? The discussion really has focused on the negative incentives for states to comply. For example, sanctions, outcasting. There's this wonderful article of Ona Hathaway and Scott Shapiro in the Yale Law Journal on outcasting, which basically means you sanction by denying the disobedient the benefits of social cooperation and membership of organizations, for example. And we argue that there is a positive mechanism, which is indispensably linked to compliance theory, but it's really under-theorized, and that's rewarding. And that was the reason why we wanted to write that article. And as the professor has said, international law is a weakly enforced system with few enforcement mechanisms. And given that the system is set up this way, we think it makes sense to think of all possible mechanisms of effectuating and enforcing international law. And rewarding adds a mechanism, we believe. It's not substituting for sanctions, but it's clearly a complement which needs to be considered in order to make the system stronger. When we wrote the article, we draw on rationalist approaches, which is common, for example, in international relations theory as well, if you think about institutionalist theories, but also, of course, realist theories in international relations. But we also draw on psychological approaches or behavioral economics. What we do in this article is providing a typology of rewards, and we explore the rationale, the potential, and the limitations of rewarding in international law. So you just heard the motivation. I tell you a little bit about the rewarding in the literature, the definition. We then turn to the rationalist analysis and then the behavioral difference rewarding can make. We then discuss the limitations and the conditions which are conducive to rewarding, and then conclude. And again, jump in whenever you feel that's necessary. So the compliance literature, when you look at it, relied implicitly on rewards, namely the assumption that enjoying the benefits of cooperation, of international corporations, are important drivers to comply with international law. And we agree on that. We just felt that they have not been explicitly analyzed as such. So we haven't looked in a systematic way at all sorts of positive inducements for states to cooperate on the international plane and to adhere to international law. What has been discussed from the rationalist perspective are the so-called 3 R's of compliance. It's the reputation which makes states comply, reciprocity, and retaliation. That's a book by Andrew Guzman, published by OUP. I think 2007, how international law works. So within those three mechanisms, there is some sort of rewarding. For example, you can have a positive and a negative reputation, but the positive sides are not stressed. So it's mainly on the negative reputation and the costs which ensue for states if they build up a negative reputation. But it's not that positive reputation also can be seen as a reward. So that's what we do in the article. We look at this mechanism on its own, and we believe it's already practiced in many areas of international law. And as the professor has said before, there are actually many examples and probably many more, which we couldn't capture in the article. And this mechanism is especially important if other mechanisms fail or in case of incapacity of states. So we think that rewarding helps not only better to understand the mechanisms already discussed in the literature, but it also shifts the focus from a penalty-oriented system to a governance mechanisms between states, because rewarding would also mean that it's part of governing, but also of treaty design, it could be. But you need to think about it. If you don't think, if your mind is not set on it, then you will not think about it. So this is what we try to achieve with the article. What is our definition? So rewards, as we understand them, are improvements in a country's value position relative to a baseline of expectations. That is important because that baseline can shift depending on the expectations and on what has been done. And the penalties are deprivations relative to the same baseline. And we distinguish 4 types of rewards. So internal and external, and we also distinguish the point of time. So internal rewards are benefits inside of the treaty, like those gains of cooperation if you make a treaty. Whereas external rewards are benefits outside of the treaty on top of the cooperative benefits which is generated by the base treaty itself. Those external rewards can become necessary when the benefit of the bargain or the treaty, that is the internal reward, is insufficient to induce accession to a treaty or compliance for some states or at a certain point of time. Okay, so of course you can say, well, if there's no state feels there's a cooperative benefit of making a treaty, then the treaty will not be done in the first place, that's for sure. Be aware that rewards come in many forms. They can be tangible or intangible. It could be opportunities for and benefits of cooperation. It can be money, it can be technology or technology transfer. It can be social approval or good reputation. So there are many ways of rewarding, just there are many ways of sanctioning. So even when we think about sanctions, do not only think about money or do not only think about military sanctions, right? There are many forms of sanctioning. There's a lot of symbolic sanctioning going on in the international world. Now, why does it matter whether a reward is internal or external? An internal reward is, of course, much more predictable for all actors concerned, but it's less flexible. Whereas if you have an external reward, it's less predictable, but it should be more flexible, adjusting to the circumstances. What we find in the treaties, so the legalata, there are often rewards and penalties combined in treaties or in soft law. So we do not confine our analysis to treaties only, because the same mechanisms can be used in soft law as well, and are used in soft law. So let me turn to the definition of the typology of rewards. And you've seen that we distinguish inside the treaty, so internal and outside of the treaty, the external, and we distinguish in this graph there also rewards and penalties. And let me start with the penalties, because this is what we usually think about. And we usually think about penalties or sanctions when we think about retaliation. So I'm basically, can you see my mouse walking there? No, okay, so go outside the treaty and penalties. So the box which is down on the right-hand side. So we think about retaliation as military and economic sanctions, withdrawal of development aid and fines, whatever you can think of. But this is usually what we have in mind when we think about sanctioning. There's also, of course, negative reputation, so naming and shaming. Okay, so we say, well, this state is not complying, and for example, the result of a court decision stating a violation could be naming and shaming, depending on what the court decision says, right? There's also, inside of the treaty, there are also mechanisms of sanctioning states. And I think the most important one, which is also discussed in the literature, for example, by Andrew Guzman, is negative reciprocity, which is codified in the Vienna Convention on the Law of Treaties. So if one state doesn't comply with the treaty seriously, then the other state can also not comply, okay? And this sort of reciprocity is very important in international law. So you withhold cooperative or other benefits within the treaty, that's limited to treaty parties, of course, and non-performing their obligations. There's also outcasting, and there's a great article by Ona Hathaway, which added actually to the 3 R's of Andrew Guzman, the outcasting, which is really prevalent in international law. You find it in so many treaties in regional organizations. You basically, as I said before, you deny the violating country the benefits of cooperation, which could be trading, which could be voting, it could be many things. So think about Russia invading Crimea. What the Council of Europe did is they revoked the voting rights of Russia, not for a long time, but that's at least what they did for some time. But there are many other examples to which I will turn now when I turn to rewards. So now I go on the upper 2 boxes. Let me start with inside the treaty, the internal rewards. So here we distinguish entry rewards and compliance rewards. The entry reward basically is done by the cooperative, or is generated by the cooperative gain of the treaty. It's like you're buying something, right? So you're making a bargain because you want the bread or something like that. So that's your benefit, the cooperative benefit. But it can also be access to finance and assistance within the objectives of the treaty. For example, the WHO, the World Health Organization, would give benefits on health advice and all that sort of things. You would also have that in the Biological Weapons Convention, which would give help in case of a biological attack. But beware that not only on that, and I'm going to come to that when I come to the outside of the treaty, the external rewards, or the Montreal Protocol. So you get finance and assistance in dismantling the production of ozone depleting materials. At least certain countries do, and which I'm going to come to that in a second as well. And then you have compliance rewards. And we say, remember that rewarding or penalizing depends on your baseline and the baseline of expectation. So for us, a compliance reward is if you were outcast of a treaty or of the system, then redemption or the prospect of inclusion after previous inclusion would be a reward under our definition. You find that a lot, like as I said, with Russia and the Council of Europe, very prominently in the Financial Action Task Force, which is soft law, or in the Kimberley process, which is the trade in conflict diamonds, which is also soft law. If you do not comply, so for the Financial Action Task Force, you basically have to comply with the FATF recommendations on how to deal with money laundering and terrorism financing. If you don't do that, your state gets blacklisted, and then other banks especially the big financial centers, cannot trade with your banks. That is very forceful, because it can really destroy the financial system of your country, even though it's soft law. But you can be re-included if they say, well, now you have complied. So they take you away from the blacklist or the gray list. There are several basis of how to do that. Or CITES, for example, the Convention on International Trade in Endangered Species, it's the same thing. You cannot trade if you do not fulfill certain prerequisites. Or the Basel Convention on Hazardous Waste. So you have a lot of convention using these mechanisms. But also the use of mechanisms within the treaty, for example, the Kyoto Protocol on climate change. You could use the flexibility mechanisms, so developed countries could use the flexibility mechanisms of the Kyoto Protocol only if they had complied with their obligations under the Kyoto Protocol. So that's a reward within the treaty. And then what I find very interesting is the so-called positive reciprocity project of the International Committee for the Red Cross. So as you are very aware, international humanitarian law is often seen to be toothless and not complied with, and the ICRC would like to change that narrative, because given that reciprocity works, then if you have a negative narrative that, okay, they are not complying with IHL anyway, so we will not comply with IHL. And what they try to do is to change the narrative and to show that, well, there are actors who have complied with it. And by this means basically motivate other actors to also comply with international or humanitarian law. Now, let me turn to the rewards outside of the treaty, external rewards. That's very common in international relations as well. So-called linkages between treaties or the promise of benefits outside of the bargain. Development aid is one thing, but you would also have this, for example, you say, okay, you ratify and comply with certain international human rights treaties, and then you get development aid, or we have a trade treaty with you. It was very prominent concerning EU accession of the Balkan states, where the EU was very explicit of saying, well, you can only accede if you comply with the requests of the International Criminal Tribunal for the former Yugoslavia. So Croatia, for example, was only admitted once they had really totally complied with the requests of the ICTY. Another example are the generalized system of preferences, which if you do trade law, you're well aware of under the WTO. There are some of the developed states who have so-called generalized system of preferences, but they come with certain conditions. And the condition is basically that you ratify certain treaties, for example, the United Nations Convention Against Corruption, or certain labor standards, core labor standards, environmental treaties. And if you do that, so that's a base treaty in our framework. If you do that, then you get the GSP. Right? Or you have the same issue, for example, the People's Republic of China would reward you if you stop recognizing Taiwan as an independent state. Okay, so things like that go on all the time. There's also a positive reputation for entering a treaty generating future gains of cooperation. So this is generated by naming and praising as a means of rewarding. Think about ratifying human rights treaties. And then you also have, just as on the inside the treaty, there are also compliance rewards, meaning that you get access to finance and assistance or promoting objectives outside of the treaty. So there's sort of side payments to the treaty. And for example, the Montreal Protocol has that, because you get assistance in more things. And the Biological Weapons Convention has it, because you don't only get assistance when you're the victim of a biological attack, but you get a lot of technical assistance, knowledge transfer, conferences, building up of labs, for other purposes concerning public health. And to me, it's interesting that the BWC has seldom been mentioned now during the pandemic, because it's not the WHO, it's the Biological Weapons Convention, which has a lot of influence in building up capacity in states, and they match states. So, for example, Cuba would offer certain services, and you might know that Cuba is very well developed in medical science, and they would offer services to other countries to build up capacity. So they have like a matching service there. And then you can also have positive reputation for compliance with the treaty, which generates future gains of cooperation. And one example here is the national human rights institutions. If they get rewarded as a good human rights institution, they would, for example, have certain privileges in the Human Rights Council. Or you could think about the similar things if you declare marine protected areas, which are very important, especially if you have a network of marine protected areas that can really, really help the oceans and to recover the fish stock. So those are all examples from very different issue areas of international law, of how you can think about rewarding in international law. Now, how do we look at it? When you look from it, and I think that's the reason why rewarding was somehow didn't get any special attention in international law and in the discussion, in the compliance discussion, because a lot of the analysis done, including from international relations scholars, is rationalist. And that would rest on the Kosian, Ronald Coase, I don't know whether you've heard the name, was an economics Nobel Prize winner who developed the so-called Coase theorem, which basically says it doesn't matter to whom you initially assign a right, the other party would pay the right holder to relinquish it as long as those would be better off. They would be compensating. They would be bargaining about it and compensating. So carrots and sticks are then the mirror image of each other. So why would we analyze rewarding separately from penalizing if it's basically the same? So since rewarding leads to compliance by generating a higher payoff for compliance, whereas penalizing leads to compliance by generating a lower payoff. So that's basically the same. It should lead equally to the target's compliance, because both means that they produce the same opportunity costs. Economists or rationalists think in opportunity costs. Okay, the costs of non-compliance would be the same. But even there, we find that it is actually, from a purely rationalist perspective, we already have differences between sanctions or penalties and rewards. The first concerns Pareto efficiency. Pareto efficiency is a concept dear to economists and philosophers, basically meaning a situation is Pareto efficient if nobody can be made better off without making somebody else worse off. So you're in an optimal state of affairs, okay? But rewards can be Pareto efficient because certainly if the reward is conditional and beneficial in expectation. So if you give a reward conditionally, you can control that you don't give the reward and then the state doesn't comply. Okay, so you give it only once the state has complied, because otherwise you as a rewarder are going to be worse off. But if you give it conditionally, then that will not happen. And that means both are better off. Okay, the target state and the sender state. Whereas penalties are always Pareto inefficient, because the target is always worse off to the status quo compared to the status quo. What about the costs? Because most people would think, well, but it's too costly to reward. How can we do that? So that's certainly not the case if we talk about intangible rewards. Okay, even though they can be deflate, you can, or they can, you can have an inflation of intangible rewards. So if you reward too many countries, the reward gets worse less. But if we talk about tangible rewards, they're certainly costly when applied to many countries. And they can have third-party effects. So for example, and I put this example in because I was giving this talk in Russia, and they said, well, but you know, it's costly for Russia if Ukraine would get the reward of joining NATO. That would be very costly for us. So there are third-party effects which you need to consider if you give rewards. And then there is a so-called rewarder's dilemma, which is like the mirror image of the sanctioning dilemma. The sanctioning dilemma is a well-known figure in international relations, that you're always better off, if there is a violation of international law, you're better off if another state sanctions the violation, because sanctioning is costly. So then you free ride on the sanctioning efforts of other states. Okay, so that's well known and discussed, but we feel that it's the same thing on the rewarding side. There can be a rewarder's dilemma, so states prefer to free ride on other countries providing the reward. And penalties are usually cost, but yeah, but if we threat, if the threat of sanctioning is enough, then it's costless for the sanctioning state. But that cannot be true, because in order to be a threat to be credible, you either have a reputation for sanctioning, that is, you had already costs to build up that reputation to be really a sanctioner, or in a specific case, you might need to make it credible, for example, by sending your aircraft carriers to a certain place. Okay, so that is costly. It's not costless, and it's clearly costly on the target side. And then the third issue we look at is monitoring and the incentives to provide information. For rewards, we think that is enhanced. So you would give more information if the rewarded state has the duty of proof. And fostering cooperative relations may decrease the inclination to cheat. Whereas under penalties, you have an incentive to hide or misrepresent information to avoid the punishment. And it can also interfere with sovereign rights, for example, if you have on-site inspections or prisons under IHL, even though, of course, the state then needs to consent. What's the behavioral difference we think rewarding would make? The first issue we can discuss, it's always discussed, but we may want to shift that to the discussion, is the assumption that we can apply behavioral insights or psychological insight to states. So the first question, which is important, is what's the unit of analysis? Do we attribute behavior to the state, or do we attribute it to individuals, which then in turn are attributed to the states, for example, heads of government, foreign ministers, treaty negotiators, etc. We believe it's a problem of realistic behavioral assumptions. So rational choice theories need to justify the disconnect to realistic behavioral assumptions. And we can discuss this later. But by now, I mean, if you look at economic Nobel Prizes, economics has really thoroughly been changed by behavioral insights. If you look at the last year's economic Nobel Prize winners, including Esther Duflo last year, they all use behavioral insights. And basically the UN, the United Nations, is also now turning to behavioral assumptions and insights. And they have a behavioral analysis unit, for example, in WHO, but in several agencies and UN-wide. So psychology and behavioral economics is widely used in national law already and in IR theory. So I started this research many years ago, and in the beginning I really had to justify, and I think now I need to justify much less why it makes sense to do that. And we believe that cohesion analysis suggests that, which suggests that rewarding and penalties are really mirror images, and they're of the same coin. We think that this apparent symmetry is misleading. There are differences of rewards and penalties on human behavior. So let me turn first to the difference in perception, and I make this a little bit quick because we are running out of time. Rewards are likely to be perceived as supportive and positive. It changes the perception of the sending state. Rewards may help to reach agreements that are perceived as fair. And for third countries, visible rewards increase the salience of law-abiding behavior, and that may encourage so-called conditional cooperators. So we know from research that you usually, and it doesn't matter whether it's in common pool problems or in climate change policy, you usually have some states who never comply or never cooperate, some states who always do that, but the huge majority of states would be conditional cooperators, and they would cooperate in the moment that they believe that the others will also cooperate, but will stop cooperating if they think that the others will not. So for example, when Trump left the Paris Agreement, China and the EU on the next day said, well, we will continue. And that was important, I guess, because so that all the other states remain inside the Paris Agreement, and it's not just unraveling just because the United States is leaving, which are, of course, an important thing. Now, with penalties are likely to be perceived as negative and deterrent. Penalties can be seen as a cue that other countries are not complying. So you would see that's a mirror image of for the conditional cooperators. You see other countries are not complying, so maybe I'm not. And penalties can be considered as unfair, especially if the penalty falls on low-income countries with capacity restrictions. And that's also what you do not find. You do not find, you have many treaties, especially when we talk about multilateral environmental treaties, we sort the intent of the country, and if it's about incapacity, there will not be penalizing, there will be rewards in the form of assistance. What's the difference in response of the target country? We would assume that there are friendlier attitudes towards the source country. Rewards can stimulate compliance by highlighting mutual benefits. And a substantial reward might allow a government to sell the eventual concession as a mutually beneficial deal. So that generates a more neutral setting. Think about the North Korean way, or how, for example, the US tries to deal with North Korea. But that would be the same for hopefully ongoing negotiations with Iran. Now, reciprocity calls for returning good for good and may lead to compliance. And reciprocity has clearly been seen as one of the main pillars of underpinning international cooperation. Penalties, on the other hand, lead to distrust or even hate towards the source country. Threats can trigger stress. Stress is supposed to reduce cognitive abilities of decision-making and may result in irrational reactions in terms of benefits and costs of compliance versus non-compliance. There is literature on so-called hawkish biases, so what stress does. I'm not going to go into detail here, that also by Nobel Prize winning psychologist in that case, Kahneman. Non-compliance can be motivated by avoidance of looking weak, but that you would not have if you take a reward. And reciprocity calls for returning bad for bad and may lead to non-compliance. What does this mean for international or the stability of international relations? So since rewards are likely to please the receiver and tend to invite future cooperation, it's also likely, they're also more likely to spill over to the target's willingness to cooperate on other issues. It supports cooperation and communication. It's a de-escalatory mechanism, but again, think about the third-party effects. And intangible rewards like visits, social approvals, and praising can create trust. And trust is very relevant for international relations. Whereas penalties increase mutual dislike, they are more likely to reduce the receiver's willingness to have any future contact with the penalizing government. It leads to isolation. And with, if you have the reciprocity is in kind, it could be that the penalties may deepen conflict. What are the limitations to rewarding? Clearly moral hazard. That is, if you know the likely, or let's say the likelihood of obtaining that's again an economic notion, the likelihood of obtaining a reward when returning to lawful behavior can incentivize states to exhibit undesirable behavior in the first place, because then they think, okay, I misbehaved, then I get a reward. That's not the way to do it, right? But that can be mitigated by prior penalties for bad faith violations. Okay, so we wouldn't think about rewarding Russia for leaving Crimea because that was clearly an unlawful invasion, and we wouldn't reward that. We also thought about crowding out, where psychologists and economists show that extrinsic monetary incentives may crowd out intrinsic motivation. For example, development aid, saying, well, if you get so much development aid, then I don't make an effort. Okay, that is something you do not want to have. That is, to be precise, might be the case with tangible rewards, certainly not with intangible rewards. And then prospect theory, which is one of the centerpiece of behavioral economics, which basically says that people do evaluate gains and losses differently. So gaining $100 gives you less utility than losing $100 gives you disutility. Okay, bad feelings, good feelings, bad feelings. So economists talk in utility terms. And in the domain of loss, you would be risk seeking. Okay, so if and that's the sort of loss aversion. If non-compliance is motivated by the fear of loss, think about territory. Threatening more loss only enhances the motivation that gave rise to the problem in the first place, namely risky behavior. And risky behavior we do not want to have in international relations, right? So when the target, but on the other hand, when the target's non-compliance is motivated by prospective gains, the consideration of threats, according to prospect theory, is more effective. Okay. Now, what are conditions conducive to rewarding? It works best when the reward matches the receiver's perception of what a reward is. The reward is clearly specified, credible, and will be timely delivered. The rewarder has the capability to implement the reward and has a record of holding promises. The receiver appreciates the cooperation with the rewarder. The reward follows substantial penalties in case of grave violations of international law. And the reward is not combined with coercive measures that would cause increasing psychological costs for accepting the reward, unless you have that to deter moral hazard. So for conclusion, rewards generate mutual benefits, but are costly when applied to many countries, if tangible, but they are Pareto efficient. Monitoring and fact-finding, which is gaining ground in international law, should be more successful when using rewards rather than penalties. Rewards should be more efficient to deal with missing capacities, because it doesn't make sense to penalize a country which doesn't have the capacity, because it will not comply, right? And you're sanctioning in international law in order to bring the state into compliance. And psychological insights show that rewarding and penalizing differ sharply in the individual's behavior, and states are, of course, composed of individuals. So although the costliness of penalties and also their ineffectiveness, especially concerning sanctions, economic sanctions, has been thoroughly discussed, it remains at the forefront of academic discussion and policy. And we believe that foregoing rewarding as a potentially additional effective mechanism to induce compliance would be a mistake, since international law is a weakly enforced system. So as Rizwanul has already alluded to, so there was one H-Land bound, and I think was senior scholars discussing the articles. We were very happy to see that. And there is also a blog, Völkerrechtsblog, which is a German blog, but it's in English, with contributions from junior scholars, which were very, very, very good. And so, and they had this lollipop on their website. So I like the lollipop, so I put it in on my slide as well. So that's it from my side, and I look forward to the discussion and your questions. And I would stop sharing my screen, but I would like to mention that you can download all of that is open access. So the article is also open access in the American Journal of International Law. And I stop here.
Thank you very much, Professor. It was a wonderful talk. We do have many questions, actually, and whenever you're ready, I would like to convey each one of them to you. Professor, this is the first question. Could there be cases where sanctions would work better than rewards?
I think it depends on the sanctions. So first of all, it shouldn't be a case of incapacity. Sanctions may work if there's a bad faith violation of international law. That depends on it depends, I think, on the circumstance and what sort of sanction you're talking about. I mean, there are some sanctions where rewarding would not have worked. If you think about the invasion of Iraq, the invasion by Iraq of Kuwait, that was a sanction you wouldn't have, I guess, convinced Saddam Hussein was a reward. That's a bad faith violation. But we do know that, I mean, clearly encompassing economic embargoes as economic sanctions don't target the people we want to target. So even turning to smart sanctions, they might not be very effective, unfortunately. So you know, people try together under what conditions sanctions can be effective. There might be situations where neither sanction nor rewarding may work. Depends, right? So what I can say is for sanctioning cannot work if you have incapacity. Sanctions will not work in cases where the gain of the country is just too big. And it depends on the capacity of the country to deal with sanctions, right? So it might not be hurting you, or it might hurt you, but you will find other ways around. Think about Russia. Clearly, it's hurt by the sanctions, by the economic sanctions, and some of them are smart sanctions. And you know, think about the sanctioning of the Myanmar government. It doesn't seem to have any big effect.
Thank you very much, Professor. Here's the next question. When states would use rewards, and let's say monetary rewards, to other states, could governments face pressure from domestic constituencies?
I think they could. Just as, but they, you know, we haven't explored that, but it's a very interesting question. You know, if, let's say, the government doesn't want to ratify a certain treaty or doesn't want to pacify a certain region, and there's pressure from the populace, the citizens, to do that in order to get certain rewards, that could happen and would be very nice. But oftentimes, unfortunately, those states which would benefit a lot from rewards and monetary rewards would also be oftentimes countries which are not necessarily entirely democratic. So the pressure of the citizens may not influence the government so much.
Thank you very much, Professor. Here's the third question. Could you elaborate on cases in which rewarding may not work at all?
Well, I think it will not work, as I said, if you have bad faith violations of international law. Then you also would not want to give a reward. Let me try to think, you know, it would work in cases of reciprocity. Let's say you have a case, and I think Andrew Guzman has actually nicely put this in the Agile Unbound commentary on our article. It would work in circumstances where you would say, you have unforeseen circumstances and suddenly one state doesn't have an interest to comply with the treaty and then the other state could reward it. I think that those might be cases where it would work. And reputational, I think it always works. Retaliation, the mirror side we don't have, right? It's really the reward. So it depends, you know, also you need to look closely, you know, what matters for government, for example. Is it, for example, social approval? Would it be important for them to have a state visit in the United States? Something like that, right? And that can have national causes because they like to see themselves or present themselves as somebody on the important on the international scene. I think that it really it's very context dependent on how you use rewards. And in treaties, I think what I can say is that they are certainly necessary in multilateral environmental agreements. We think they can also be applied in human rights treaties, but it depends on the type of rewards you're doing.
Thank you, Professor. Here's the fourth question. Do economically backward states have less leeway to use rewards than economically advanced states?
Sure. If it's material rewarding. Otherwise, if it's intangible rewarding, I would say that's not the case. And I come back to sovereign equality. So, you know, if you have a praising, let's say, of a country X by, let's say, 60 countries, 80 countries, no matter which countries those are, that would matter more than if you have just one rich country praising it. Okay, so again, it depends on the type of reward. But clearly, when we look at trust funds, for example, where also they generate rewards, then those are mainly filled in by the developed states, not by the less developed states.
Thank you very much, Professor.
You know, the status. I think I want to mention that the status of a country and its international reputation is important to countries. So, and here that doesn't depend only on rich countries, what status a country has. It depends on the community of states. And here it's really one state, one voice. Right?
Thank you, Professor. Is there any difference in how democracies and authoritarian regimes are likely to respond to rewarding?
I would not necessarily say so, because even, I mean, could be that it depends on the reward, I think, but even authoritarian regimes like to present themselves, or the governments like to present themselves as well regarded on the international plane. So even for them, it seems to matter what's the international signal. So let's say you have an authoritarian regime, which is often violating human rights, but then it does something and that would be rewarded officially, let's say in the annual report of a human rights committee, that would matter to that regime. Because all regimes, no matter whether they're democratic or authoritarian, they long for some sort of legitimacy in the eyes of their people. So in that, if that is true, I mean, there might be some exceptions who really don't care about it, but I think overall that holds true. And that is, it would matter to them how those rewards are given out. And then I think what is important, that if you have authoritarian regimes and you have sanctions, they would usually, there's this sort of, that's well known in the research, you have this rally around the flag phenomenon. So leaders would really try to paint the sanctioning states as enemies and foes, and they usually succeed in that. And the reward would still give them a way out and not doing this, because that usually really deters the goal which the sanctioning countries really want to achieve.
Thank you very much, Professor. Here's another question. As in some cases, let's say in the case of international investment law, international law may impose obligations on non-state actors too. Could you share your insights on how non-state actors may respond to rewards?
That is interesting. I mean, I think here we haven't thought about it. I would think, I mean, it depends, because, you know, until now, honestly, under international investment law, it is always the investor who sues, right? So the violator is always the state under international investment law, even if you consider counterclaims. But, you know, I'm not going to go into the details of investment law, but counterclaims are a difficult thing to do. That might be changing with redrafting of the treaties, but the status quo of the law is such that it will be very difficult to have any counterclaims. But let's assume for a second that that will change, and investors could also be found liable for violations of environmental law or human rights law or things like that. Would it make a difference for a company if it would get praising? Let's say, imagine a world where you have, in a way it's already there, you know, companies do care about a reputation of being, of having good CSR politics and adhering to certain norms, and they hate of being shamed for having violated human rights norms or environmental norms or things like that. So I think it would work the same way. And look at all the efforts of companies of you know, trying to make sure that they appear CSR compliant. And of course, we have also ever more home state laws on that. But yeah, I think it could work.
Thank you very much, Professor. Next question. Why do you think it is the case that rewarding is less explored as an option than penalty in international law?
Less explored as?
Less explored than penalties in international law.
Well, I think really because people thought, I don't know. I mean, I don't know how many of you have kids. The intuition is always to say no. And if you do that, then, you know, you get penalized. And I think psychological research has well shown that that is not working very well. It's not conducive to the goal you usually want to achieve when educating the children. And in a way, you have to switch your thinking. And I think really that, well, first of all, rewarding probably becomes more important in a world which is more legalized. It's not that rewards are something totally new, absolutely not. But we have, of course, more treaties, for example, where we have global public goods at stake. Think about the international environmental treaties, where rewarding might make more sense because you want to incentivize a lot of countries to cooperate and to comply. In order to create that public good, that might be one reason. And then purely theoretically speaking, I think it's really the rationalist influence in international relations, but also international law. We thought about it as two sides of the same coin. It's not. But I guess this is why it was neglected.
Thank you very much, Professor. Professor, this is our last question. Could there be sometimes a risk that rewarding could be counterproductive in that some states could commit a breach with the hope of a subsequent reward?
Yeah, I mean, that's exactly the moral hazard problem we are discussing. So under those conditions, you need to penalize first, okay, in order to prevent the moral hazard to exactly that problem. I think there's one other issue which we also briefly discuss. You also have an incentive, because economists always thinking about incentives, right? So you would also have an incentive as a state to understate your capacity in order to get assistance, for example, financial assistance, right? So that is something you also need to take into account. So we are not saying that rewards are a panacea. They're not. We are just saying that they have been under-theorized. We should take them into account. We are not saying they're always working, but we also draw attention to that sanctions often do not work. And still the international community is mainly thinking about sanctions, at least the academics. And it was interesting because Ian Johnston from Fletcher was one of the persons who wrote an article, Unbound Contribution, on our article, and I was later in contact with him, and he said, I really loved it, and I was, I don't know, he's involved in some cybersecurity issues, and it seems that the government officials said, yeah, we need to think about rewarding as well. They haven't thought about it, because we think in sanctions. We traditionally think in sanctions. And I don't know, I mean, ask yourself, when you teach international law, when you think about international law, how we enforce international law, we always think in usually material sanctions, meaning military or monetary, so economic sanctions or military sanctions. And that's in our brain. And I mean, you know, the government negotiators have that in their brain as well, because they heard international law from professors who had that in their brain. And this is what we wanted to change. And hopefully we succeed.
Professor Aaken, thank you very, very much. It was a delight to have listened to you. And for those of you who might have missed any part of our professor's lecture, please do note that we will have professor's lecture uploaded in our YouTube channel. Professor Aaken, thank you very, very much. Once again, we do look forward to hearing from you once again in some issue related or unrelated to rewarding. Thank you very much, Professor.
Thank you.